Further hearing in the appeal, Stanford International Bank Limited, acting for its joint liquidators.
Professor Watson-Gandy, good morning.
Good morning, my Lord. My Lord, last night we left off on the principle that, on my submission, that unfair prejudice relief is only available against third parties, where the third party is a wrongdoer. I've found 3 cases in which relief against strangers has been given in unfair prejudice. First of those cases is F&C Alternative Investments, which you can find in your Authority Bundle, Volume 1, page Divider 10, and first passage in which the test being applied can be found at 200 at 1096.
So
sorry, my Lord.
6.
I'm so sorry. I am. Books.
Oh dear, Professor, what's gone wrong? It's a bad start.
It's a bad start, it is.
But it is 1096, isn't it, you want?
Oh yes, it's the paragraph number.
Yes, the words is so connected to the unfairly prejudicial conduct in question. Yes.
Thank you, my Lord, for rescuing me.
Could you give us the electronic page?
The electronic page is 2015.
Ah, that's what we wanted.
That's much better.
Yes.
Right.
And at the bottom of the page, of that paragraph 1096, sufficiently implicated to warrant relief being granted against him.
Sorry, where is that?
It's the same paragraph 1096. It's the final sentence.
Oh gosh, it's long, isn't it? Yeah.
Amazing judgment. It's a tour de force, this judgment.
Judges at first instance work very hard.
I know. Lucky he's here now.
Whether what was done involved unfairness in which the relevant defendant was sufficiently implicated. That's the point.
That's the point.
Very well, that's number 1. What's number 2?
Well, I mean, where does that take us in this case? It means that all these people were sufficiently implicated as suitable defendants.
What I'm trying to derive from the 3 cases is a principle that for a stranger to be fixed with a remedy under unfair prejudice, they have to be part and parcel of the misconduct. They can't be just a happy beneficiary. They have to be involved in the misconduct itself.
Is that what this is saying? Whether what was done involved unfairness in which the relevant defendant was sufficiently implicated?
Yes, indeed.
Well, I mean, I don't know what the facts of this case were, but how were they implicated?
It's attribution of responsibility. It looks as if he's looking for some sense in which the third party can be said to be responsible.
I see. So you say that would help you in this case?
At least on the facts that relate to the.
It was an unfair prejudice case.
Yeah.
Yes.
Yeah, I see.
So the submission is that the defendants who are strangers to the company have to be implicated.
Yes.
What about pension fund trustees? Are you coming on to Clark and Cutland?
Milady, what we say is that if they were also wrongdoers in the company, it does not matter that they are not. One can still seek relief against them, even though they are not the traditional category of directors or shareholders.
They might be intermeddlers of some kind.
Deborah's as what?
But are you coming on to Clark and Cutland, which is where there were pension fund trustees who were not members of the company, against whom relief was given? Perhaps you could have a look at it.
Which case is this?
Have we got this in the Bible?
No, I don't think so. I didn't realise that was a submission.
Hang on. There's a case called Clark and
Cutland.
Well, it was not in the bundle, and we haven't given notice to council. It's difficult for them on their feet to
absolutely.
deal with it.
Possibly, you've mentioned 3 cases. We've got the first.
Apex Global is the
It is conceivable that when we finish this case and discuss it and look at the Clark case, we may be inviting written submissions on it. But that's all down the line. I don't think it's fair, and Lady Arden wouldn't think it was fair to expect submissions on your feet on this case. So, number 2, please.
Number two is Apex Global, which is at divider 6. And the relevant page is 1895 in the record.
Very small print. But I think I can blow it. I'm almost adding to my item. Oh, yeah. Oh, golly. It's terrible.
Removing my glasses, I can...
There comes a point where you blow it up and it just doesn't get any better because it all falls to bits and turns into pixels.
Was this not wasn't this not reported anywhere, Professor Watson-Gandy?
I believe this is...
Which paragraph
I
are you
understand
wanting?
better copies of Apex are being just about to be produced.
Which paragraph are we?
It's paragraph 125, which reads as follows. In my judgment...
Well, if they're about to be produced, let's read from
In fact,
the...
Mr. Fenwick read this to us, did he not?
He did.
Yes.
He did.
Thank you.
Thank you.
That's the concept of responsibility again, isn't it?
Well, the passage that we refer to in paragraph 125 is the sentence which says non-members of a company
Yes.
who are alleged to have been responsible for such conduct can be joined as respondents, and in an appropriate case, such non-members can be made primarily or secondary liable to buy the practitioner's shares. And words we pick up on are the words responsible for such conduct.
And number 3?
Number 3 is Low and Farhi, which is at divider 16 of the bundle. 2144. The passage appears at 2150 at the top of the page. Lindsay J., after reviewing the relevant authorities, concluded that as a matter of jurisdiction, the language of 461, which states, "Court may make such order as it thinks fit for giving relief in respect to the matters complained of," confers a very wide jurisdiction. I agree. Shall not repeat the analysis leading to such conclusion. In my judgment, where, for example, the unfair prejudicial conduct involves the diversion of company funds, a petition entitled as a matter of jurisdiction to seek an order under section 461 for payments to the company itself, not only against members, former members, or directors allegedly involved in the unlawful diversion, but also against, and this is the point where we pick up, against third parties who have knowingly received or improperly assisted in the wrongful diversion. So, another category. My learned friend addressed you in fairly emotive terms in relation to 2 aspects, and the 2 aspects which we take issue with. Firstly, is the expression of he describes the net winners as being overpaid. The net winners, of course, are those who have received their capital back, and some or all of their contractually entitled interest. So they are overpaid in the sense that the milkman or the stationery company or the photocopy service providers has got paid what they are contractually entitled to, and they're only overpaid in the extent that one is able to sort of perhaps rewrite history in the context of a pari passu distribution to say that they got more. If you look at it in terms of splitting up all the losses and all the assets, they got more than their pari passu share. Second,
that's linked to Mr. Fenwick's submission that the terms of the contract were that they would be repaid only to the extent that there were monies available. What do you say about that submission?
That's how he makes that point.
What do you say about that submission in relation to the terms of the contract?
What he says regards that is that the reference that is made to only being entitled to be repaid is simply linked to a warning, to a financial risk warning. It's not part of the contract.
No. Yes?
The second point we pick up on is the suggestion that the preference creditors, those who received payments in the last 6 months of the bank's collapse, were in some way selected for special treatment. My Lord, what we have is actually in the first bundle is the evidence adduced by the liquidator in the form of Miss Beverly Jacobs. And
Volume 1 of 5?
My Lord, yes, 472. It's probably worth flagging that page because I will come back to it for another passage.
472.
I don't think that's in bundle volume 1. I think it's in volume 2.
So sorry, my Lord.
Is this paragraph 25 and onwards?
Paragraph 25. She says, during the final, this is an employee of the bank who gives evidence.
Oh, she's an employee.
During the final months of SIB's existence, I recall that a decision was taken to reject any request to prematurely redeem US accredited and investor CDs. This meant only matured US accredited investors who requested redemptions or withdrawals were paid once this decision was taken. I do not recall whether a similar decision was taken in relation to non-US investors. And then she produces a copy of the bank's response. The response confirms the approach the bank was taking in general. I also attach, and she of course attaches a copy of the disclosure statement. I believe the paragraph headed early withdrawal penalty at page 8 is referred to in SIB's report response to the request for an early withdrawal from a particular US accredited investor. The decision to refuse withdrawal from US accredited investors holding non-mature CDs would have likely come from the president of the bank. I'm not certain whether he received instructions from the directors or SIB shareholders to cease processing these non-mature accredited investor accounts.
So what's the point you construct upon that evidence?
What we say is that the decision was to so far a decision was made to treat one category differently from another. It was simply to enforce a stricter interpretation of the maturity.
So no special preference was given to any category?
No, it was.
Could you just remind me, was there no right to require early payment?
There is a right to require early repayment subject to a penalty, and so I suppose the difference in treatment was to stop people, stop investors from exercising that default provision.
Even subject to the penalty?
Subject to the penalty.
So that you discriminated in favour of one group, those who had matured CDs?
Your ladyship is right. Perhaps it's a better way of putting it, my lady. My lord, the next point is in relation to the discretion of the way that discretion was exercised by Mr. Justice Warbank. If you're against me on my other points, that comes to be reconsidered. Of course, as you've already, as you appreciate, it's an appeal against a discretion. So the test is, of course, not whether an imperfect decision is being preferred, but whether it's a decision which reasonable disagreement was not possible.
Okay, can we just, for the purposes of listening to this part of your argument, remind ourselves what a Beddoe application is? Is it an application for a declaration by a judge that it would be reasonable to expend the corporation's funds in the proposed litigation?
That's roughly right, yes, my lord. As far as I recall, that's.
I mean, I've been looking at re Beddoe half an hour ago, and that's what seems to be suggested. If, therefore, we are talking about the reasonableness of expenditure, what evidence was there before the judge as to the likely cost of the proposed litigation? And indeed, the balance between likely expenditure and likely recovery, in light also of the fact that presumably the enforcement of any order made in Antigua would have to be taken elsewhere for enforcement purposes.
None in relation to the aspect of the case in which I was involved. However, I think my learned friend might be able to address you on that, in case that came up.
Were you not before Warbank, J?
I was before Mr. Justice Warbank, but I was brought in to assist on one aspect of that, which was to advance to put forward the submissions that might be advanced by creditors who had written in to complain about the proposed course. We ended up of letters raising objections, and my role was to digest that. And
So you,
I mean,
after you.
in a traditional Beddoe application, I mean, beneficiaries not infrequently seek to address the court along the lines of, this is taking a sledgehammer to crack a nut, or it's just disproportionate expense, it's wasting the trust fund on litigation with an uncertain outcome. But that was outside your remit, was it?
My remit was simply to provide a sort of sensible digest of what the counter.
But you wouldn't oppose this proposition, would you, that if it was shown on the usual basis that there was a good ground for proceeding against X and that it was a cost-effective piece of litigation, that the court could approve that? Yes,
Of course, that's the sort of balance prospects of success, the likely ordering. It's a balance of factors.
Yes, so you reminded us it was discretionary. Yes, and what are your submissions on that?
It suggested that Mr. Justice Warbank prejudged the case. In fact, see from I can give. There's at various points he's careful to flag up the fact that he isn't prejudging the outcome, but of course forming a preliminary view of the merits is a necessary part of the Beddoe process to assess whether it would be sensible to give permission. I think he reminds himself that he's not prejudging it. Paragraphs of his judgment 255, 353, 362 and
Sorry, can you say those again?
I'm so sorry. 255, which is at page 252.
Yes.
353, which is at page 266 of the record. Paragraph 362 at 268 of the record. Paragraph 397 at 273 of the record. And paragraph 403 at page 274. Suggested that he erred insofar that he had regard to the investors' expectations. Says that that was a consideration which was relevant, firstly to the section 204 test, which takes into account the expectations of the parties when assessing whether or not there's unfair prejudice or not, but also in terms of whether it would lead to an unjust outcome. There's a case called Grant and Manala, which appears in the authority bundle at divider 12 and page 2054.
I'm so sorry, what's this case called?
It's a case called, I'm so sorry.
Grantian Manor,
That's
page
my lord.
2038.
My lord, your lordship's correct. I'm so sorry.
Which paragraph?
It's paragraph 32. It's at page 2054. It's a quotation from a commentary on Companies Act. It says, but M.S. Blackman in commentary on the Companies Act, volume 2 at 9.4 cautioned that the very wide jurisdiction and discretion section 252 confers on the court must, however, be carefully controlled in order to prevent the section from itself being used as a means of oppression.
252 is which section, is which act? Or which?
It's the, in this case, it's the South African unfair prejudice provision.
But your main point here is that the judge dealt with the reasonable expectations of the unpaid creditors when deciding that there was an arguable case of unfair prejudice. So that, although on the particular issue about whether to make clawback claims, he was looking at the expectations of those who had been paid.
That perhaps conveniently takes us on to the Cook case, which...
Sorry, can I just be clear where we got to on this? I mean, assuming the liquidator had power to do this exercise at all, the judge decided that it should be limited as a matter of his discretion in the way he describes at pages 281 and 282, so as not to allow clawing money back from the people who had got it. Now, assuming he had the power to do this at all, do you defend that exercise of discretion? Or, yes, you do.
Yes, I do,
Yes.
my lord.
Right. But to the extent that he decided he wasn't going to claw money back from people who had already got it, do you say that he didn't have power to do that anyway, or that it's simply that it was a proper exercise of his discretion?
We say both. Our primary position is that it would be wrong to claw.
Yes.
But if in terms of an exercise of discretion, assuming that I'd fail on the other points, we say that would be a proper exercise of discretion, because it addresses the hardship of forcing.
Yes, well, that's what I understood. I just wanted to be clear that was your position. Yeah. Thank you.
But would it go further than simply saying it's a question of hardship, that it's actually against the scheme of the insolvency legislation to claw back from people who've got it? My Lord referred to them as equities darlings.
But that goes to the first.
That's your first point.
Yeah,
And then your second point is, even if that weren't right, you would defend it as a matter of discretion. But your first point is the one my Lord and Lady makes.
So, Professor Watson-Gandy, what you say about an analysis that the judge's disposal meant that people who'd got more out were immune from suffering anything, whereas people who'd got less out, and thus were claimants in the liquidation, suffered. Where's the logic behind that?
Comes back to the quotation from falls where the loss lies where it falls.
It's absolutely biblical in source. It's biblical in source.
Rain falls on the just and
I mean, it's a common feature of liquidation. A creditor who gets paid the day before the company goes into liquidation gets paid. A creditor who might have been paid if the liquidation happened 2 days later doesn't get paid. He has to queue up and get whatever scraps are available in the liquidation.
That's it.
The argument against it is surely, well, it's completely happenstance. And it depended on the decision of the directors we've just seen from Miss Jacobs, that they would pay out some and not others. And some people got paid out, and therefore, since they're all in it together, there should be some levelling out. That's the argument, isn't it? I don't understand there's any other argument.
In essence, what we as regards the distribution of the balance,
Well, let's look at this now. And the board is extremely grateful to you for having risen to the occasion and, in response to Lady Arden's inquiry, produced another bundle.
sorry, my lord.
Thank you. So where do we go first? Russell Cook?
We start with Russell Cook.
Yes.
In essence, this was a case where Clayton's case was being considered as a route forward, which is the first in, first out, as a means of distribution. And basically, the case concerned monies that had gone into a solicitor's account, which the plan was that they were to be invested and allocated to various loans. That was the theory. In practice, it didn't happen quite according to plan. Some of the investments could be allocated to specific loans and securities, but a vast majority could not. The question, therefore, that the court was facing, Ms. Justice Lindsay, sitting at the time, was what to do with the pool of money. First divided one. Reasoning starts at paragraph 34. Explains the alternative of the common misfortune.
So is this getting money back into a pool, or is this distributing money that's in the pool?
It's as regards distributing money in the pool.
Quite.
But he explores the other
Yes. Thank you. 34.
34. It says, as an alternative route to the pool solution, Miss Tipples relies upon a notion described as common misfortune. So far as can be seen from the authorities cited to me on the issue, the notion derives from a dictum of Judge Learned Hand in Re Walter J. Smith and Co. and ex parte Feuerbecker, referred to both by Lord Justices Wolfe and Leggett in Barlow Clowes International. The dictum was commenting on how a depleted fund had to be divided between claimants, and in particular with whether or not the rule in Clayton's case, which I will come to, was to be applied. The dictum cited in full in Barlow Clowes and in part is as follows. The rule in Clayton's case is to allocate the payments upon an account. Some rule had to be adopted, and though any presumption of intent was a fiction, priority in time was the most natural basis of allocation. It has no relevancy whatever to a case like this. Here, two people are jointly interested in a fund held for them by a common trustee. There is no reason in law or justice why his depredations upon the fund should be borne equally between them. Throw all the loss upon one through the mere chance of his being earlier in time is irrational and arbitrary, and equally a fiction as the rule in Clayton's case. When the law adopted a fiction, it is, or at least it should be, for some purpose of justice. To adopt it here is to apportion common misfortune through a test that has no relation whatever to the justice of the case. In Barlow Clowes' case, Lord Justice Wolfe referred to a common misfortune. He earlier referred to Justice Morris's comment in Eastern Capital Futures, where that judge had referred to there being no suggestion in that case that any client or class was more or less innocent than any other, and that the equities between them were thus equal. Justice Wolfe referred to the shared misfortune again. Lord Justice Leggett returned to the subject of common misfortune. However, such references cannot be enlarged into support for a proposition that wherever there is shared misfortune, clearly discernible separate property rights are to be surrendered or overridden. Investors may, so to speak, be in the same boat, but that of itself does not require anyone to give up the life jacket to which he is already wearing. This is what we say we point to as an indicator that distribution of what's left, not a
let alone that he should get back into the boat, which is sinking.
Yes?
As I continues, as I come to when examining the argument for the separate trust solution, there were undoubtedly some cases of specific allocation of some assets, legal charges, to specific and identified investors in proportions inter se, which were ascertained or ascertainable. Mrs. Tipple's argument, based on common misfortune, would require that even those specific allocations were to be overridden by reference to such a misfortune, having befallen all investors. As I've said argument, as Ms. Wanacott argues, would require some form of divesting of those specific property interests in favour of the pool. Indeed, even to suppose that misfortune was common may be unjustified in some cases, where the charged property specifically allocated might prove sufficient to meet the specific debt which was given as security. There is, in my judgment, no way in such the invocation of common misfortune can lead to a pooled solution such as to require all charged properties to be SPIP assets from which all liabilities are to be met.
So is there common misfortune here?
There's a common misfortune insofar that one looks at the distribution of the pot of funds. This and the associated case law raise is an issue as regards what is the correct way of distributing the residual pot that is left over. And the reason that is particularly germane here is, of course, this is not a trust fund. This is a pot of money available, which would, in relation to a banking account, so a traditional sort of scenario in which Clayton's case case arose.
I mean, as between the investors who got their money out and the investors who didn't, is there misfortune? Is there a common misfortune?
Well, we would say, to some extent, the answer is yes, because some of the net winners didn't recover all their contractual entitlement as regards interest. So, to some extent, they have a claim for their lost return that they were contractually due. As those who that recovered nothing, they have a claim both for the investment and for interest.
It's always very difficult with analogies to be certain that one is putting them in the right place. But I had thought the common misfortune might be the Ponzi scheme, in which all the investors were actually victims in one way or another, unless those who were paid out, of course, retain everything that they were entitled to. So, on that basis, the common misfortune is one suffered by everyone, in answer to my Lord's question. But your point is, it only authorises you to distribute what is actually in the pot and not to claw back. And I see the argument. When we're talking about the pot, is it just the general assets in the liquidation?
It is the general assets of the liquidation.
What's happened to the trade creditors and the preferential creditors and so on?
Say that they would have, if you had a secured creditor or a preferential creditor, they would have a claim.
Right. So
But
they will be dealt with in the normal way. And are there other unsecured creditors then, the trade creditors? Right.
But there's no sense in which this is a segregated fund, as I understand it. If there are other trade creditors who are not wearing a life jacket of being a pref or a secured, then they're in the same lifeboat.
My Lord, yes.
There are no client dealing rules.
What Russell does do is it explores three choices as regards the distribution of the pot. Paragraph 55 explores Clayton's case, first in, first out. And we derive from that Clayton exception. There's a quotation is that Clayton exception can be set aside by what's described as a small counterweight. 6 counterweight that's applied there is that the fund was being dealt with. It was not being paid out in the same order that it was being paid in. A second alternative is then looked at. In place of the common misfortune, which is described as the North American method. This is described by Justice Dillon in Barlow's Clouds case as a system used to avoid loss falling on the depositor who happened to have made the first deposit in point of time. If that reason does not exist, whereas here Clayton's case is not being applied, in any event, the prime reason to adopt falls away. The method is in any event complicated and may be expensive to apply. Accordingly, I prefer the pari passu system as the system adopted in Barlow-Clouds case. It is, to my mind, the system least unfairly distributing loss on an account should have been dealt with in accordance with the Solicitor's Rules 1991. be assisted on assistance as to what the North American method is.
Mary, what do you think?
No, I don't think so. Not if it's not being relied on, no.
Perhaps I can take you to divider 5, which is the most recent case on this issue. Which is a case called Charity Commission and Framji and others. Paragraph 54 of that, which is says as follows: it is clear from these situations that at least two members of the Court of Appeal, Justice Wolfe and Leggett, regarded the rolling charge method, also referred to as the North American method, as in principle as the one likeliest to produce a fair and just result, although all three judges were agreed that it was impractical to adopt it in the Barlow-Clowes case, itself on the grounds of complexity and expense. Apart from its currency in North America, the method has also been adopted in the general rule in Jersey, see in re-esteemed settlements, where it is referred to by the court as the apportionment method. Although it has never been applied in an English case, I'm certainly prepared to proceed on the assumption that it would be open to me to adopt the rolling charge method, or some variant of it, if I was satisfied that it provided a fairer result than either the Clayton's case or pari passu distribution. What is proposed, however, is not a full application of the rolling charge method. It is agreed on all sides that this would be completely impracticable in respect of all periods before 6th of June 2013. The problem is not so much a complexity of the calculation, which I imagine a suitable computer program could easily cope with, but rather the reconstruction of the raw data, which would be needed in the absence of any computerized record keeping by Dove Trust adequate for this purpose. Thus, the proposal, which I've already indicated, that the available funds should be divided into two pools, one constituting sum available for distribution after the final run of payments, 5th or 6th of June 2013, and the other constituting all donations received after this date. Each pool it is submitted could then be distributed pari passu amongst those entitled to share it. Such ultimate recipients may be entitled to share in both pools if donations were Then at paragraph 60, he concludes, despite the initial attraction of the tool pool approach, I've come to the conclusion that it should be rejected in favour of a single pari passu distribution of the entire fund. The most important point in my mind is that the website operated precisely the same so far as the donors are concerned, both before and after 6th of June 2013. There's nothing to alert them to the fact the Commission had appointed an interim manager and a reasonable expectation of the donor who made a gift on the 7th of June, in my judgment, have been the same as those of a donor who made a similar gift 2 days previously. The situation remained essentially unchanged from the perspective of donors until the website closed in 12th of July 2013.
61.
In those circumstances, I think the fairest solution is to regard all unpaid recipients as participants in a common misfortune brought about by the way the donation scheme was managed by trustees.
Yes.
If the matter is viewed in that way, there is no good reason to differentiate between victims depending on when the donations were made, or to seek to divide up the available pool of assets on the basis of a minute examination of changing beneficial entitlements as and when payments were made in and out of it. There is admittedly an element of justice involved for the most recent contributors to the pool, but it seems to be avoidable once a decision has been taken in favour of pari passu distribution, which itself responds to a very basic human feeling that, when faced with a common misfortune, all those affected by it should bear the burden equally.
Yes, thank you.
Have you found any case in which common misfortune has been applied to reallocate the assets of a company in liquidation among its creditors, otherwise than in accordance with whatever the liquidation scheme happens to be? Because these cases are all about trust funds, whereas here we're talking about the assets of a company in liquidation being distributed. And we're talking about beneficiaries here, I think, aren't we, rather? Creditors.
The difficulty I have in answering that is that the common misfortune outcome closely corresponds with traditional pari passu distribution
Yes.
and liquidation.
Yes.
And so being able to say which of the two applied, it does have the attraction of a consistency with the present position under an ordinary liquidation. One can see sort of Clayton's scenario of a first in, first out working insofar that one looked at the company whilst it was alive. There was a bank-client relationship, and there was also different maturity dates. But certainly, what Russell, Cook and Prentice does allow us the sort of flexibility of approach on a liquidation, which is consistent with the insolvency regime, and it also takes into account what we're looking at here. Is trying to find a way to find an economic administration of a large volume of debts and dealings.
Cost-effective, cost-efficient.
Cost-efficient.
Yeah.
So far that we'd look at rolling fund as an alternative. Lifespan of the bank as a whole. See that it would be impractical to reconstruct all the bank's dealings to do that. Also, one has to bear in mind that the cost of doing so, not only in terms of the cost from the standpoint of the liquidators, but how that would dilute the available funds for
Yes. So where do we go next?
Where we go next is flowing from that in terms of discretion. Where we get to is what common misfortune leads us to is a conclusion pretty close to the conclusion Mr. Justice Walbank actually reached in his conclusion. As regards forcing the parties to priority, as regards the expectations, it's also consistent with that. Say that there was a trading period where the parties had loaned money to SIB on a perhaps no risk, but not no risk basis, and therefore reasonably expected. So payments back to them at that stage was consistent with their expectations. As regards the start of the run of the bank, from September 2008 to the liquidation, the SIB staff didn't know about the Ponzi scheme or that the company was insolvent, and like it is reasonably expected that these payments to be met. I referred to the statement of Beverly Jacobs. Paragraphs 23 and 24 deal with her understandings of what was happening at that period in time.
Are you asking us to go back to that?
Could you go back to page 472? The paragraphs are 23 and 24. second half 2008, there was a marked increase in redemption requests to the bank. I consider that this was a run on the bank in the traditional sense of the term. Particularly in early 2009, a number of redemption requests were such that SIB had difficulty meeting them all. Indeed, the bank on many occasions asked Mr. James Davis and other persons handling treasury function for the bank's investments to make more funds available to meet these requests. Notwithstanding these attempts, there was an ever-increasing backlog of customer requests, which was in the region of $100 million at any given time. During this period, I believe the bank was only experiencing liquidity problems as regards that of the monetary crisis in 2008. I was, however, until the bank was actually wound up, always of the view that there would have been sufficient funds to meet the withdrawal requests once the bank had eventually liquidated some of its investments. So what we derive from that is that not only was there an expectation on the part of the investors that they were going to get paid, but also from the bank's ordinary members of staff, there was a belief that it's as usual. Of course, it's quite clear that once SIB goes into liquidation, the expectations of everybody changes. That expectation is treated in the normal, as creditors in the normal insolvency process, at which point in time pari passu distribution as regards creditors kicks in. My Lord, the final issue before your Lordship is the question of ex terpi causa. We derive from, your Lordships have already been referred to Patel and Mirza. We derive following principles from it. Firstly, that a party cannot be allowed to profit from its own wrongdoing. The law should be coherent, not self-defeating, and not condone wrongdoing. Factors that are taken into account are seriousness of the contract, the centrality of the contract, and whether it was intentional, and whether there was a disparity of culpability. Paragraphs we refer to are paragraphs in Patel and Mirza 99 and 107. We don't suggest that this is a new application. We'd urge a new application of the law. Position was in front of Mr. Justice Warbank. There was an awareness that the matter was going to be considered, but Patel and Mirza hadn't been decided. So the law that was being applied was Tinsley and Milligan, which was the law at that time. For the Court of Appeal, the matter was before them as an issue, but it wasn't necessary to determine. So in essence, the applicability of the present of ex terpi causa to the present facts has never needed to be considered.
Yes.
In essence, we put the point of the case in this way. Liquidator's claim was for the return of a benefit to SIB, and the SIB was engaged, their case is that they were engaged, SIB was engaged in serious and intentional fraud.
But I mean, the whole point is it's not for the benefit of SIB in any meaningful sense, it's for the benefit of people who've lost out.
But the liquidator sits in the shoes
of course, but I mean,
SIB.
if I was looking at what the purpose of this litigation is, it's not to help anyone who's been guilty of fraud, but to help those people who suffered. Your lordships in terms of disparity in culpability, what one looks at is this is not a situation where the bank is seeking a remedy against it's not Surround Stanford seeking a remedy against the bank. It's the bank's seeking a remedy against the victims of the fraud. I mean, I understand how you put it in theory and how you do the analysis. It just seems to me very unreal on the facts of this case, but I may be wrong. You set it all out very clearly in your case.
Yes, you have. It's 109, isn't it? It's the last paragraph of your case. Is there much more to add to the points there made?
Those were the points that I saw.
Yeah, well, we've got that in front of us.
I was grateful. Unless I can assist you further, I think I've, unless my
Mary?
nudges me at this moment, which is everything I
Professor Watson-Gandy, thank you very much indeed. Now, Mr. Johnson, you've already followed once in the most helpful manner. Do you follow again?
No.
Thank you. Mr. Fenwick.
My Lords, I have a few points of detail I want to pick up along the way, and then some substantial submissions. I hope I won't detain you much beyond midday, if at all.
That would be perfect.
The specific points I want to deal with, in no particular order, are these. First of all, you asked Professor Watson-Gandy about whether there had been any estimates given of cost, and there was reference to a Beddoes application. This was, of course, not a Beddoes application. It was an application by the court-appointed liquidator to the court for guidance. And if you look at the judgment at page 268 of Volume 1, paragraph 362, the application for directions was not a plenary trial of the issues. It was also not a forum at which defences could be fully explored prior to established facts. The level of review was for the various possible grounds for relief and possible defences to be considered in principle to determine whether any of these defences are sufficiently certain to exclude steps proposed by the joint liquidators. Where steps are not excluded, it's open for defendants to raise these and any other defences for further consideration at trial. Now, my instructions are these, that there was an application for appointment of an amicus. The liquidators made an application which is in tab 14 at page 285, so we can perhaps pick that up. In that same volume, and it's paragraph 1 arguing issues surrounding the propriety and legality of certain proposed actions the joint liquidators were seeking to take, and a paragraph 9 on page 288. The court dealt with the preference creditors application in October 2013. Protocol was set out to deal with any challenges to the actions proposed, and then the court made an order, letter sent out to 4,400 creditors, and correspondence back. The position was that was done, and the court permitted the liquidators to withhold funds from certain of the creditors before they made the first, and I think the only distribution which has been made, which is 1 cent in the dollar. And the court, the tribunal or the committee will see that a proposed step which would increase it by a further 24 cents in the dollar was a highly relevant matter on which to seek guidance.
Mr. Fenwick, I'm so sorry. I said it was a Beddoes application because I think there's been a reference to it being a Beddoes application. Let's look at the application and see exactly what the liquidators were asking for.
Yes. Well, that's at tab 14. And it's paragraph 1.
Page?
On page 285. The court shall appoint counsel as amicus for the purpose of arguing questions, issues surrounding it.
No, I'm sorry, Mr. Fenwick, I didn't make myself clear. What was the initiating application for guidance? Let's see the precise terms. This application for the appointment of an amicus was an interlocutory application, surely.
Yes, if we can go to page, to file 2 of the record, tab 16, page 311, we see the order. I don't think we've got the application notice in the bundle. Made in October 2013 by Justice Wallbank. And we see over the page at 312, upon considering the management of SIB in the 6 months up to February 2009 permitted redemptions of certificates of deposit to the unfair prejudice of the interests of other depositors, so prima facie unfair prejudice. Considering that the liquidators have discretion to make the withholding and standing, and it was ordered at paragraph 1. I should do the last whereas, upon considering the creditors affected by the proposed remedy should have an opportunity in the first instance to challenge the proposed remedy by means of communication with the joint liquidator. So we were allowed to make adjustments to the creditors' claims.
This is an interlocutory order.
Interlocutory order. In the normal way, when liquidators appointed by the court go to the court for guidance on a particular specific matter.
I mean, it happens. It happens almost monthly in large liquidations.
I'm so sorry?
It happens almost monthly in
Yes.
large liquidations.
Yes.
Yeah.
And in this case, Justice Wallbank has been incredibly helpful in giving guidance all the way through. At that stage, the cost of the amicus exercise was considered, calculated at $300,000 US. That's in, I think, bundle 1 at page 292. We didn't get to the cost of individual claims because it was always intended to do a case-by-case analysis or a group of case analysis in order to see what it would cost to pursue certain classes of claims. Yes. And that was also included.
In order to make that judgment, you would have to expend costs.
Yes. And that's why we went to the court in the first instance. Can we withhold money? And can we please find out what people say? Lots of objections, so we applied to appoint an amicus.
But the $300,000 was just to fund the amicus.
Yes.
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 I think
That was...
we would be more interested in whether any court was given any estimate of the cost of the litigation it was inviting
No, the cost of
the court
litigation
to authorise.
would obviously be higher.
Yes.
But again, if one can identify 20 or 30 investors who between them account for $200 million, and you'll then have 3,000 to account for small packages, then you draw a line.
Yeah.
But when you tell me, and I fully accept it from you, this is not a BEDER application, were you not, however, seeking guidance which would represent protection for your liquidators from any challenge to their expenditure of corporate funds on the proposed litigation?
In part, and there's a distinction here between the role of a trustee who has to administer the trust fund, but when they want to protect themselves, and also to seek guidance, go to the court with a Beddoes type application, and a liquidator whose primary function here is to seek the guidance of the court as to what is appropriate. So we're not just doing it to cover our backs, we're doing it because we want the court's guidance on what is undoubtedly a difficult question. Do we allow $1.3 or $1.5 billion to lie where it is so that the other creditors only get 1 cent in the dollar, or do we do something about it where they may get up to another 24 cents in the dollar? So that's that point. The next specific point I want to pick up, Lady Arden drew attention to Clark and Kurland. Cutland, yes, which was a Section 459 claim. It was against an innocent third party, was a pension trustee, but I should be cautious before drawing too much comfort, because the pension trustee were trustees for the wrongdoer, and therefore it's not exactly an innocent third party, but it is an innocent third party in name. So I don't want to take too much from it, which I'm not entitled to. The next specific point I want to deal with, Sir Andrew Longmore suggested that a Section 204 application, the claim must be against the company or a director. Not so. It's an application to the court, and the court will then give directions as to what should happen. not so limited. It was suggested, I think, by my Lord Wilson, that the Section 371 may lead to the conclusion that recoupment might damage the development of Antigua as a business centre. In my submission, that is not a fair conclusion to draw. The fact that so many creditors should be treated unfairly without any recourse is, in my submission, more significant. The 2016 Act, which we've seen, there is no explanation for it. It would, in my submission, be wrong in circumstances where these appeals were ongoing for the court to draw any conclusion from that Act that it was in some way intended to delimit the extent to which the Antiguan legislature intended to allow preferences in relation to international business corporations. I'm nearly at the end of my points. I have two more, I think. My Lord Wilson, in observing in relation to my paragraph 60, thank you. Can we just turn to paragraph 60 of my case? It's page 1623.
Yes.
And the references we made to Lewin observed with a slightly raised eyebrow as to why we didn't see fit to refer to 421/004. As Professor Watson-Gandy forgot to point out, we do mention it 3 lines later in paragraph 61, expressly, and for the definition of a bona fide purchase for value without notice. So we had it in mind and we drew it to the attention of this committee. Always happy to be found wrong, but on that particular occasion, I think we had covered the point and we're not withholding anything from your attention. That takes me to, I think, the last specific point before I deal with some general submissions, which is this. Fairfield and the various points that my Lord Briggs was making to me about this being a Fairfield type case, perhaps in terms of the contractual entitlement.
I'm not sure. Well, contractual entitlement, yes.
Of course, I won't repeat my submissions. These are secondary victims in Fairfield, whereas we are the primary victims, rather than as the funds themselves were primary victims of Madoff. But it's interesting to note that Fairfield was referred to in the first instance judgment. Indeed, the learned judge, Justice Walbank, asked for submissions on a number of matters before reaching his decision, including in relation to Fairfield. Submissions were made. It was not suggested by anybody that these creditors who'd received funds were in the same position of strict entitlement as in Fairfield. That may not matter if your lordship find that they were, but can I just show you what the conclusion was of the learned judge when he dealt with it at page 267 of volume 1 of the record, the paragraph 356. And there he said, this is a section in which he's reaching his views.
Which paragraph?
356. Customers of SIB were also entitled reasonably to expect that the terms of their CD contracts be honoured, including that they should become entitled to be paid a contractual interest. Again, Professor Watson-Gandy's submissions were all related to the expectation of interest for the time value of money. And we submit that the situation here is indeed different.
But they're not, there was no suggestion in the disclosure statement that they would have their entitlements reduced by reference to what had what had been a default of a third agent, namely the company and its officers, in relation to other investors. There was no hint of that, no.
The last point I just want to pick up, which I should have mentioned, which my learned friend turned to momentarily, he took you to volume 2 of the record, page 472, paragraphs 23 and 24. And for the purpose of submissions I'm going to make in a moment, it's relevant to look at what was said at 25 onwards.
What page?
472, my lord.
Thank you.
During the final months of SIB's existence, I recall a decision was taken to reject any request to prematurely
Did we not read this earlier this morning?
23 and 24 you read.
Didn't we first read 25 and 26 and then read 23 and 24?
If you did, I missed it. It's entirely
let's read
my
it.
fault.
Let's read it again.
The point is that only matured investors who requested redemptions were paid once the decision was taken. Others had their application refused. 26, that would have come from the President, Mr. Stanford. And so one sees that if one follows the approach suggested by both the learned judge and by Justice and by my learned friend Professor Watson Gandy, not only is it first come, first served, but it's some of those who came first are served and some of those are sent away without dinner. And in my submission, that emphasizes the unfairness of leaving things where they are, which I now want to turn to. And starting very briefly from the outset, once one looks at Galantis, which I believe you have in loose copy, Galantis at paragraph 39, to which I think the question by my Lord Carnwath as to how this fits in with his argument that you can't have post-insolvency use of this kind of 204 equivalent. We see not only the default to pari passu, but it's clearly anticipating it does apply within insolvency. And unless it's said to be per incuriam or wrong, then in my submission, that in itself is sufficient to dispose of the first point, i.e. whether it can be used in liquidation. The liquidator is a proper person either as an officer or at the court's discretion. There is undoubtedly oppression of 80% of the investor creditors. So if we get to that point, and we have Section 204 available to us, in my submission, much of the approach of my learned friend starts from the wrong end of the spectrum. It's not what can we squeeze into Section 204, but it is, given, as the board said in Galantis, a remedial discretion of great breadth, it's what it is appropriate to exclude from it that one should look at. And prima facie, if the wording is wide enough, all of these remedies should be available. They're available against unjust enrichment and a remedy of a modern preference treatment. And as you heard yesterday, where common law preference is not available, where there has been a request, because it has to be voluntary without a demand, there is no realistic possibility of the common law preference applying unless it were to be much extended towards the statutory one. So why not take Section 44? Section 44 would allow a preference to be corrected and all the unfairness in the cases referred to, the examples of happenstance of time, could be avoided. Now, there are two mechanisms under Section 204. The first is preference, and why not use the very preference legislation which Antigua itself has identified, and we have limited our aspirations in relation to the preferential creditors rather than the net winners to the last 6 months, which as a starting point before seeking guidance is, in my submission, entirely appropriate. The unjust enrichment route, unless I'm wrong about Fairfield and the contract, is entirely appropriate. But if one looks at the cases overall, and here I come back to what Lady Arden was suggesting as we finished yesterday, there is a common misfortune here. All of these unfortunate individuals have been defrauded by the Ponzi scheme, perpetuated and hidden and pursued on a massive scale by Alan Stanford. One would expect that to be dealt with fairly by sharing the misery between all those who are affected by it, subject to equities and defences such as change of position. And when one looks at the Barlow-Clowes line of cases, and I'm going to look briefly at a couple of things in Barlow-Clowes in a moment. Those were, of course, cases where there were proprietary rights. The funds still belonged to the investor because they'd never been used for what they were intended for. And whatever kind of trust or constructive trust or quis-closed trust you impress upon it, they were proprietary claims which would normally give rise to tracing remedies. The default position, as Mr. Justice Henderson as then was said in Charity Commissioners, is what the lawyers call Clayton's case and what the accountants call FIFO or first in, first out. But as Mr. Justice Henderson rightly pointed out, that is easily displaced when fairness requires it. Now, before looking at Barlow-Clowes, if you can override proprietary claims, which normally will take precedence over other claims for loss, in order to achieve fairness, it is in my submission going no further, or not more than a very small bit further, to say that where you do not have proprietary rights, but some people have received money early in excess of what they would be entitled to had the insolvency been known and dealt with way back in August or September 2008 or earlier, that they should have to make a repayment. And we would submit that the happenstance that they managed to get paid in those last 6 months, leaving 80% with a 1 cent in the dollar, subject to the other claims we're pursuing, when on a fair distribution taken in August 2008, there'd be something approaching another 24 cents, is plainly unfair, and it should be dealt with and remedied if it can be fairly. And we would submit that, subject to defences, alteration of position, hardship, which will be considered by these liquidators, if necessary by the court before money is spent, and pain and anxiety is given to those who've received money, it should be permitted. And I just want to look in that context, finally, therefore, at 2 cases. I'm going to make sure that the paragraph which Ms. Sandels wants me to read, I don't miss as I go through. But
when you're saying that the money can be brought back from the winners, do you mean that irrespective of whether there's a cause of action in law, are you asking for a direction that they repay irrespective of a cause of action, or only if there is a claim in unjust enrichment or a claim in constructive trust?
Or a preference type claim. And we would submit Section 204 is wide enough to permit the court to provide a preference type remedy, which is lawful because it's subheading H of Section 204. So whether or not there's a claim in unjust enrichment, and I'm not going to repeat my submissions on that, then 204 is wide enough to permit it. And it's tempting to say that where the court is overriding proprietary interests in the line of cases we've been looking at, it should also be capable, in the wide discretion of the court, this wide flexible remedy, of providing a right to require repayment. If there are specific defences, then they should be allowed. But I don't think I need to go that far, but I will if I have to.
I think it would be helpful if you'd be a little more precise about what would constitute an unlawful preference type claim, or whatever it is you say. I think one's entitled to know what are the parameters of, because you've got your common law preference type claim, and you say that's not good enough. So.
Well, it's not good enough because it's not available on the authorities as...
Yes, I know why you say it's not good enough, but we're entitled to ask you, well, what is good enough, and how is it defined?
What is good enough, and what we've said throughout, is that we should be permitted, subject to looking at them and at the merits, to pursue repayment from all those who receive money in excess of their pari passu entitlement in the last 6 months before the appointment of the receivers, and that we should be entitled to look either going back all the way or to such date as the court thinks is appropriate, either here or by remission to Justice Wallbank, against those who received, in addition to the repayment of their investment, notional profits, which in fact were never earned, but were actually taken from misappropriation from other investors.
How far does that go back in time?
I'm sorry?
How far back in time?
Well, it's put at the moment in the guidance all the way. I can well understand that if I'd been there at first instance, and if your lordship asks me now, that is probably going too far, although it may be appropriate to look at the circumstances. There is only 200 million of net winners, and there should be a cut-off point. Where it is, whether it's a year, 2 years, 3 years, is really a matter for consideration. It would probably, in my submission, be appropriate for the liquidators to be directed to identify who the net winners are, how much they've got and where, and if there are any special features, so the court can have a look at that and say, well, those are clearly out, and those ones you can have another look at. But that's the limit of what we've been asking for throughout and what I asked for today.
Is that, where's that most clearly formulated in your case? I just would like to have a clear formulation of it.
I entirely understand. I'm going to ask Ms Sandels to find the best place whilst I finish my submission so that I don't prove myself wrong about timing.
And the only amount you want to recover, because you put it various ways in the last few minutes, is it the net profits over capital?
For the net winners, it is profit over capital.
Right.
For those paid out in the 6 months,
yes,
it's everything over and above their pari passu entitlement. So if they were entitled to 24 or 25 cents in the dollar and they've received 50, I want to recoup the extra 25 or 26.
As I understand it, by pari passu entitlement, you mean what they would have got if the bank had gone into liquidation 6 months earlier.
Exactly.
It's not a contractual pari passu entitlement, it's what they would have got if there'd been an earlier liquidation. Yeah, sure.
Can I go to there's only the two authorities I want to pick up. Barlow-Clowes, first of all, which I hope you have in the For All England version. And the particular paragraphs that I want to look at, subject to being told something different from Ms Sandels, is on page 42. This is in Lord Justice Wolfe's judgment, he then was, just above letter F. The approach in summary which I would adopt to resolving the issues raised by this appeal are as follows. While the rule in Clayton's case prima facie available to determine the interests of investors in a fund into which their investments have been paid, the use of the rule is a matter of convenience if its application in particular circumstances will be impracticable or result in injustice between investors. It will not be applied if there's a preferable alternative. Here it won't be applied because this will be contrary to either the express, inferred, or presumed intention of the investors. If the investments were required by the terms of the investment contract to be paid into a common pool, this indicates the investor did not intend to apply the rule. If the investments were intended to be separately invested as a result of being collectively misapplied by BCI, a common pool of the investments was created. Because of their shared misfortune, the investors will be presumed to have intended that the rule does not apply. Where's the paragraph you want? And then on page 46, in the judgment of Lord Justice Leggett, just above letter C, the court goes by what must be presumed to have been the intention of the investors. If I'm right, they contributed what they thought was a collective investment fund. It matters not, once contributions have become mixed, whether the depredation was committed on a small or large scale, systematically or sporadically according to a plan on the spur of the moment. What matters is the combined fund was depleted. Misconduct by Barlow-Clowes is relevant for explaining why, but it would make no difference if it was conducting its business in a lawful manner, which gave effect to the general intention of its investors. Yes. The investors did not expect their money to be kept in a bank account used for purchase of yacht. Whatever the reason why the losses were suffered by the fund, it accords with what presumably should have been the intention of the contributors, that they should share rateably in what remains of it. And I want to go back, if I may, to Lord Justice Wolfe on page 41. It says, middle page, on the facts I would not apply the rule, even if the documents indicated that BCI was under an obligation to create separate funds for each investor, so overriding contractual rights. In default of this obligation, as part of the continuous misapplication of investors' monies, BCI did not create separate funds but a pool into which the investors' monies were collected. This is a fund into which the investors are entitled to trace proprietary remedy. However, it's a pool, the creation of which they would not have contemplated. In these circumstances, the court has to presume what would have been the intention of the investors had they contemplated the creation of this pool. So far as that intention is concerned, I have no doubt it's correct to presume the investors would have intended that what could be salvaged as a result of the common misfortune they had suffered should be dealt with in accordance with the third solution, not in accordance with the rule. It can be presumed they would not want to subject what was left of the pool to the vagaries of chance which would follow from the application of the first in, first out principle. I appreciate this means I've taken into account misconduct in determining rights. I see no reason why what actually happened to the funds in the hands of BCI. It's no reason to ignore what's actually happened. So taking that and applying it to this case, whatever the contractual rights, the intention would have been that if somebody had known in September or August 2008 that this was a Ponzi scheme, then they would all have expected to share equally, not that those who came first to the trough should feed at the expense of the others. In Barlow-Clowes, there is references to the case of Diplock, which we referred to in our written case, and I just want to pick up two short quotes from that. It's in volume 2 of the authorities at tab 27.
Page?
It starts at 2327 and I'm going straight to 2335. And so this is, the part of the decision is in relation to proprietary claims, but it also deals with claims in personam. And halfway through the main paragraph, third paragraph, we turn, however, to the claims in personam, about 7 lines from the end. It's, in our opinion, impossible to contend that a disposition which, according to the general law of the land, is held to be entirely invalid, can yet confer upon those who ex hypothesi have improperly participated under the disposition some moral or equitable right to retain what they've received against those whom the law declares to be properly entitled. We also add that in determining the difficult question which the appeals have raised, it's immaterial the respondents are charitable institutions of the most deserving character. Considering the application of the principles of equity, it does not seem to us there is any different standard of conscientiousness for charitable or other corporations from that appropriate to an individual. This was a case in which monies had been paid out incorrectly under a will, and the Court of Appeal ordered that funds should be recouped even from innocent recipients.
Recipients were all volunteers. They weren't purchasers for value.
I'm sorry?
They weren't purchasers for value.
No.
They were all volunteers.
Yes.
So the poor volunteers had to pay back.
Yes.
Yes.
And that's the case in a preference type case. It's clearly not
No,
the same.
well, with respect, in a preference case, they are equities darlings, but preference is a very special statutory scheme which overrides that.
I understand that.
It only applies to creditors, effectively.
Yes.
I think in Ingram and Little, which was also Lord Diplock, as you recall, I think he was then Lord Justice, there were two victims of the fraud on the purchase of a motor car, and it was said by Lord Diplock that where there were victims of fraud, they should share equally.
And we would submit that's appropriate. I think the last passage I wanted to pick up in this particular case is at page 2349. That last paragraph, what conclusions to be drawn? No exhaustive formulation. Seems to be established the equity may be available equally to an unpaid or underpaid creditor, legatee, or next of kin. Claim by next of kin will not be liable to be defeated merely in the absence of administration by the court, or because the mistake under which the original payment was made was one of law rather than fact, or because the original recipient, as things turned out, had no title, was a stranger to the estate, though the effect of the refund in the last case would be to dispossess the original recipient altogether, rather than produce equality between them and the claimant and other persons having a like title to that of the recipient. There's no authority in logic or in deciding a case such limitation to the equitable right of action. What we say is where, in reality, there were not funds left, and where, if the fund had been properly administered, nothing would have been received by any of these individuals in the last 6 months, then the misfortune should be shared. Unless I can assist you further, that's all I wish to say.
I think not. Thank you very much indeed, Mr. Fenwick. The board is very grateful for the submissions received and will take time to consider the advice which it will humbly give to Her Majesty in relation to the disposal of this appeal.